Good afternoon, everyone.
Good afternoon.
Good afternoon.
Hello.
Hello, everyone. Should be excited. Afternoon. No?
Yes.
Oh, last class. I don't hear much excitement.
You all didn't want to send us the link for class last Saturday,
Why say that?
Because we didn't get
Sorry.
sent it. It's usually sent 9 o'clock in the morning, and after checking my email for 3.5 hours, I gave up.
Oh God.
My apologies. My apologies. I forgot about you guys.
Oh, thanks.
Hold on. You don't look like you almost forgot about us again today.
So someone again too. Yeah, sorry about that.
Yeah, I decided to be proactive instead of missing a class. I decided to reach out for some assistance.
Remind you, okay, here's the deal. This link doesn't change, okay? This link stays the same for the remainder of the class, okay? So
Last class, God is good.
yes,
This
as
is
long
our
as
last class, and it changed every week before, so there was no need for me to believe it would be the same last week.
okay, yeah, no, yeah, this stays the same every week.
Yeah.
Denise,
All
why
right.
you back in class on the last class?
Huh?
Sorry.
No, I was asking Denise why she begging for class on the last class.
Oh, I'm not, but I felt it necessary to mention that
Before
we didn't
someone
get a
assume you want the
class.
next class.
There is no other class. Calm down. All right. So you got a case called in the matter of the Soothsayer Limited.
Yes, but
Okay.
not with much explanation as to what it was for.
That's all right. You'll get the explanation. Doing it. We'll talk about it. All right. So today is on the last chapter, which is on liquidation. And as you know, liquidation is a process and where companies' assets or their properties are redistributed to creditors or to shareholders in accordance with the order of priority. So once a company is dissolved, it doesn't exist. But everybody knows that during a liquidation, the liquidator can actually examine the company to see how management actually conducted its affairs when the company was in operation. So there are two types of liquidation. We have voluntary and involuntary. So generally the members or the creditors can wind up a company. If it is solvent, they can appoint a liquidator. If it is insolvent, of course, the creditors apply to the court to have the company involuntarily wound up. So for voluntary liquidation, the members resolve to voluntarily wind up and dissolve the company. Involuntary, of course, they go to the court to make a winding up order, and it's done on the petition of a creditor or an aggrieved shareholder. So the liquidator exercises his power under the direction of the court, and it is required to obtain the consent or authorization of the court whenever it's entering any transaction. So the two types of voluntary liquidation is liquidation either can be by the members or it can be by the creditors. By the members, the process is where the directors and the shareholders decide to put the company into liquidation, but the company is solvent. When the creditors seek a voluntary liquidation, and that's where the directors or the shareholders, they decide to put the company into liquidation, and the company is insolvent. And insolvent means that they don't have sufficient assets in order to pay all of the company's debts. So for voluntary liquidation, Under Section 2 of the Winding Up Act, a company can be wound up under any circumstances in which a company is incorporated under the Companies Act. And that Winding Up Act refers to both IBC and to CAC. So under the Companies Winding Up Act, an IBC may be compulsorily wound up by the court, or it can be voluntarily wound up by resolution pursuant to the Articles of Association or upon its expiration or under the supervision of the court. So under Section 211 of the Winding Up Act, a company may be wound up voluntarily if the period, if any, was fixed for the duration of the company, expires according to its articles, or if there is an event that occurs and that event would have been stipulated in the articles, and the event, when it occurs, it would say in the articles that the company is to be wound up upon the completion of whatever the event is or upon the occurrence of this event. It can also be done when a resolution requires the company to be wound up voluntarily and has been passed by a majority of no more than 3/4 of the members, and those members have to be entitled to vote. And the fourth way is where the members pass a resolution that it has wound up voluntarily because it is insolvent. So as under Section 212, the voluntary liquidation of a company is deemed to commence at the time of the passing of the resolution. And in that resolution, it authorizes the winding up of the company or the expiry of the period or the occurrence of the event as specified in the Articles of Association or the memorandum. So the process for voluntary liquidation for an IBC is, first step is the resolution by the members or the directors in accordance with the Articles of Memorandum, the appointment of a liquidator, the approval of the plan of dissolution, the execution of the Articles of Dissolution. The Articles of Dissolution are submitted to the Registrar General for registration. And then the liquidator takes responsibility for winding up the company's affairs. So under the IBC Act, there is provision for the charge of interest on debts. The next step is the liquidator advertises for creditors during the liquidation process. And you normally see those in the newspaper. The notice of dissolution has to be published within 30 days of the registration of the Articles of Dissolution. The liquidator will then prepare a statement of account. The liquidator submits the statement to the Registrar General that the winding up has been completed. The registrar then strikes the company off the register. And upon receipt of the notice and the certificate of dissolution, which is issued by the registrar, it certifies that the company has been dissolved. The date of the certificate is the date of the dissolution of the company. The liquidator then publishes this, that the company has been dissolved and has been struck off the register in the official gazette. And that's upon the issuance of the certificate of dissolution. So that's the liquidation process. Any questions?
I do have a question.
ahead.
When a company is voluntarily liquidated, the resolution, I think, as guided by the IBC, I'm talking about, well, IBC Act or the Companies Winding Up Act is what is used. It states that the directors and or members have to, that they can meet the liabilities of the company. But quite often when these companies are being wound up, there are no longer any assets. So I'm just wondering how that works, as well as when if the company no longer has assets, can a third party, that is the beneficial owner, provide an indemnity or a, whatever the word would be, to state that they would meet the liabilities of the company.
Why would they want to do that?
Because it's required that the company, like I said, either by a resolution of the directors or members, I think both have to include it, that the company can meet its liabilities. And if the company no longer has any assets, it would not be correct for the directors to resolve that the company can meet its liability.
But are they seeking liquidation?
Yeah, voluntary liquidation, not court guided or whatever.
Because I mean, the process is to advertise that you are in the process of liquidating.
Yes, that's all done. I mean, the liquidation process is followed, but I am just talking about that actual resolution where if the company no longer has assets, it cannot meet its liabilities, the company itself. Therefore, in order to have it liquidated without applying to the court, would it be acceptable, like I said, that the beneficial owner provide, proof, whatever, that they can meet the liabilities of the company? Because quite often these companies don't have any assets. That's why they're liquidating. And I know a lot of, I know a very large company that I work for, they would not liquidate prior to all assets being transferred, distributed. It had to have a zero balance before the liquidation process would even begin.
So, sorry, Miss Archer. In that case, can the resolution not state that the company has can meet its obligations?
That's what I'm.
Can the wording? Yeah.
No, there's a requirement that you have to state. I mean, that the company, as was just mentioned in this manual, the company has to be able to meet its liability.
Ooh. Because I'm wondering if cases where you can't, if that just comes out of the rail, okay, but it has to.
That's what I'm trying to figure out, because I'm saying, why would the beneficial owner himself make that indemnification?
Because at the end of the day, I mean, I'm not necessarily talking about operating companies, of course,
Yeah.
A holding company, because the assets are theirs and the directors are not going to resolve that the company can meet the liabilities, because then the onus would be on them and there's no assets in the company. So in order for that company to be liquidated, there has to be an indemnification from somebody to say the liabilities will be met, although in most cases there are no liabilities and everybody's aware there are none. But to fulfill that, that provision, whatever, something has to be in place.
I'm just trying, in my mind, I'm trying to figure out if I've read of a case whereby such a document or such a declaration was made and then it was challenged in the courts.
Yeah, I guess that's what I'm really trying to determine. I mean, because that is a route that was taken. And I am just wondering, I mean, there was very little risk, like I said, but at the end of the day, would that invalidate a liquidation if challenged, and how do you get around it? If you have to resolve that the company can meet its liabilities, yet it has no assets, how do you get around that? Apply to the court in all those cases when there really are no creditors?
Yeah, but then by him signing that form, he exposes himself to a liability.
Well, if he wants it liquidated, that's what he's going to have to do, because there's no other way to liquidate the company.
Okay, so if you wish, if you could send me a note, so let me see if I can find anything on the English side where that may have been presented. I don't remember it being done locally, but send me a note. Let me see.
Sure, I will do that. And I do have another question, actually. I do believe under the Companies Winding Up Act, it states that once that first notice is published in the Gazette, that there has, you must wait 30 days in order to submit the liquidated statement or statement of account.
Yeah.
And I know in many cases that process is not followed and a company is still processed for liquidation. Is that, do you know of any cases where that could be an issue?
No, I don't remember reading any either. But I'm wondering what, okay, that's another one I'll have to check out. Because if the law states that it's it says published within 30 days. That's the publication of it.
Yes, that's just the notice, but the Winding Up Act also stipulates, if I may be wrong, but I don't think so, that there has to be a 30-day wait between publishing that notice. The creditors have to be given 30 days in order to contact the company with any liability, any money owing to them. And I know, like I said, that process is not followed because the IBC Act, the original winding up provision that was replaced by the Companies Winding Up Act, that was not it, and the registrar still follows that process for dissolving or liquidating an IBC under the original provisions of the Act.
Well, I'm going to, let me see if this is it. No, you'll see there is a case. The case, when we go through it, they're going to talk about what is just and reasonable. So I don't know if there's a matter that went before the court that turned on that point, but you'll see how the court, I guess, interprets when there's been a repeal of a section and what is reasonable in terms of the effect of what they call the gap in the legislation and whether it was intentional or not.
Yes, I read that actually. That was rather interesting and still hasn't been fixed.
No, that's another thing. It's been almost what? 2017, 20, yeah, almost.
Yes.
Yeah. And that's not being addressed.
Anyway, yeah, so those were my questions with respect to a voluntary liquidation.
Okay, all right. So if you send me a note, I'll start with the first one.
Okay, thanks.
Yes, not a problem. All right. So section 165, an IBC can be struck off if it no longer satisfies the requirements of sections 14, 38, and 44. And the company struck off remains liable for all claims, debts, and liabilities and obligations. And the striking off does not affect the liability of the members, the directors, officers, or agents. And then, of course, a company, a creditor, a member, or liquidator can, within 5 years, following the date of the striking off, apply to the registrar to have the name restored, paying the requisite fees. And the company name can be restored to the register. If the company has been dissolved or for the period of 5 years has expired, the company, the creditor, the member, or the liquidator can apply to the court to have the name of the company restored to the register. And the effect of struck off the register, you still incur liability, and the creditor can bring a claim against the company, and the court can appoint an official liquidator. So if a company is struck off under section 165 and remains struck off for a period of 5 years, the company shall be deemed dissolved, and the registrar may, if in the best interest of the company, apply to the court to have the company liquidated and appoint an official liquidator. So in the case of, in the matter of the Soothsayer Limited, at the Registrar General and Credit Suisse Trust Singapore. This company was voluntarily dissolved on the 21st of May, 2015. And then 4 months after its dissolution, the first plaintiff, who is Mr. Bidzina, discovered that there had been fraudulent activity in the management of his accounts held with the bank, including unauthorized purchases of shares, imprudent trading activity, and false reporting. And an employee of the bank admitted to the criminal matter. So in the interim, the civil action had commenced against the bank in Singapore. And what is the man name again? Mr. Bidzina is seeking a restoration from the Bahamas. He went to the registrar to see if he can join the company in the proceedings in Singapore. So the Registrar General objected to the application for restoration. And she objected because on the grounds that 1, there is no conclusive evidence of fraud, and 2, that the plaintiffs, Mr. Bidzina, were not proper parties to bring the action, and so they didn't have any standing before the courts, even though the liquidator had come in to support the application. So the Registrar General point was that there was no provision in the IBC Act or its amendment in 2010 to restore dissolved IBCs to the register. And the court can do it under its inherent jurisdiction, but it had to be done on the basis of fraud. So when you look at the matter itself, the legislative framework, the court said a good point is to start from section 166 of the Act, which was repealed. And in that subsection 3, it said, if a company has been dissolved for a period of 5 years, has expired under subsection 1, the company or creditor, member, or liquidator thereof may apply to the court to have the name of the company restored to the register. And then she said in section 166, the restoration to register, if the name of a company has been struck off the register under section 1652, the company or creditor, member, or liquidator may within 5 years, immediately following the date of striking off, apply to have the name restored. So it says plainly, this section relates to companies that have been struck off under section 1652. Section 1652 refers to the section under the IBC Act because section 165 was not repealed. Section 1652 provides for the striking off of companies which have failed to respond to an order for compliance from the registrar. It does not speak to the situation where companies have been voluntarily dissolved. Then went further, said that the new section 166 subsection 3 provides as follows. If the name of the company has been struck off the register under section 1653B, the company or creditor, member, or liquidator thereof may within 5 years, immediately following the date of the striking off, apply to the registrar to have the name of the company restored to the register, and upon payment of the restoration fee, the license fee, and the license fee in amount stated in the notice. The registrar shall restore the name of the company to the register, and upon restoration of the name of the company to the register, the name of the company shall be deemed never to have been struck off the register. So it says a reading of the ensuing subsections clearly refers to the restoration of companies to the register for the non-payment of fees. Indeed, the entire section 166 speaks to the restoration of companies for the non-payment of fees. Unfortunately, and for unknown reasons, the new section 166 has no provision for the restoration of dissolved companies. as was his former counterpart, Section 1663 of the IBC Act 2000. The short answer is that the IBC Act 2000 and the IBC Amendment Act 2010 contain no provision for companies which have been dissolved. So then they went to the common law cases and they reference Repinto Silver Mining. And it says the only case in which it is desirable that what has been done should be undone is where there has been a fraud by which someone is injured. Such a fraud must be the fraud of somebody, and the person guilty of it would be personally liable, but it may be that it would also invalidate the proceedings. The second case they relied on was Re London and Caledonian Marine Insurance Company. And in that case, the judge said, where some particular reason exists why that which has been done should be undone, as in this case, for instance of fraud in connection with the proceedings, there should be some way of setting aside these proceedings. So the discussion ensued, and where both sides presented their cases. And the counsel stated how the bank employee admitted that he had committed various offenses and he had fraudulently mismanaged the accounts in the company. And he listed 9 different instances of that. Then he said that the trust has suffered significant losses, including losses associated with assets held in the company's account, in addition to losses associated with the fraudulent activity in Raptor referred to above. The bank also caused significant multi-million-dollar losses to the company by accepting to execute instructions to convert what was then a majority fixed income portfolio into full equity. So the bank employee admitted his guilt to the fraudulent activities. So the registrar, based upon their standing, they were saying that there is no evidence that the dissolution of the company was the result of fraud. So that was their stance. And they're saying that the court should not exercise its discretion to restore the company to the register, even for a limited purpose of joining in the litigation in Singapore. So in analyzing the case, it said it is common ground that the IBC Act 2000 and its amendment in 2010 contain no provision for the restoration of a company which has been dissolved and subsequently struck off the register. It is also common ground that under its inherent jurisdiction, the court may, after considering the circumstances under which an IBC was dissolved, restore that IBC to the register once it is satisfied that such dissolution was perpetrated by fraud in respect of the company. The judge said, in my opinion, there is conclusive evidence to show that a fraud has been perpetrated in respect of the company that led to the dissolution. And they also say that the sole purpose for the plaintiffs coming to the court was to restore the company to the register to join in the litigation that had already begun in Singapore. So it said that that being considered, that this is a proper case for me to exercise my discretion and restore the company to the register for the limited purpose of commencing, defending, or joining in litigation, which has already begun in the High Court of Singapore. The judge also said, even if I am wrong, I still will continue with my decision. So she said, as reiterated earlier, Section 166, subsection 3 of the IBC Act 2000 dealt with a company that has been dissolved. However, that section was repealed and replaced in 2010 by a new Section 166, which makes no provision for restoration of dissolved companies. It seems difficult to envisage that the omission was intentional, rather than a mistake, because a comparative study of the other financial jurisdictions, for example, Jersey and BVI, both have specific legislation providing for the restoration of dissolved companies. It would be puzzling for the jurisdiction to intentionally choose to remove it from the statute books when other competing financial jurisdictions have specific legislation. It is fallacious to believe that if judges have the discretion to restore a dissolved IBC to the register, then the floodgates are opened. So as Dr. Maynard jocosely stated, there must be a flood for the gates to open. In any event, in my considered opinion, judges already have that jurisdiction. To restore a dissolved company to the register is always in the discretion of the court. And then what the judge did is give an example of the BVI legislation and how they deal with companies that have dissolved, and then the process for it to be put back on the register. So the judge, the counsel for the bank and the liquidator brought out the point that you have to look at what is just and reasonable or fair and reasonable that a dissolved company be restored. And the counsel argued that section 166.6 and 168 of the IBC Amendment Act 2010 may apply to restoration of a dissolved company to the register. Section 166.6 provides, for the purpose of this part, the appointment of an official liquidator under section 168 operates as an order to restore the name of the company to the register. Section 168 states, the court may appoint a person to be the official liquidator in respect of a company, the name for which has been struck off the register. The counsel also said that the court on multiple occasions has restored dissolved companies to the register, even in the absence of legislation. And he said, by obvious mistake, I believe, when section 166.3 of the IBC Act was repealed and replaced by the new section 166 of the IBC Act, Amendment 2010, which makes no provision for dissolved companies to be restored to the register, I do not believe that it was the intention of Parliament not to make any provision for dissolved companies. And then he cited the Bahamian case of Hyam, Bahamas versus the Attorney General of the Commonwealth of the Bahamas. And in that case, Hyam was made on the grounds of 1, mistake, and 2, it was just and equitable, or just and reasonable that the company be restored so as to enable it to distribute the assets which remain to be distributed and which ought to have been distributed before the company was dissolved, and which ought to have been distributed before the company was dissolved and was done in at least 2 previous Bahamian cases. And he gave the names of those 2 cases. So the judge, in looking at what is just and reasonable, came to the conclusion that the company should be restored. For the purpose of joining in the matter in Singapore. So it says, so she said that the dissolution of Soothsayer Limited is void ab initio. The certificate of dissolution dated May 21st is null and void. And the name of the company be restored to the register for the limited purpose of commencing, defending, or joining in proceedings before the courts of the Republic of Singapore. And Soothsayer Limited is deemed to have continued in existence as if its name had not been struck off. And the official copy of the order was to be delivered to the registrar. And as Denise was saying, she did a postscript and saying that the legislation should be amended. But as we said, it's been 5 years and it has not been done. So in most instances, if there is a company that has been dissolved and wants to be restored, they would follow the case of Soothsayer Limited. Any questions, comments?
I found it interesting that, I don't know if it's a liquidator or the beneficiaries who had been advised that it'd be a simple process. So obviously whoever they were advised by, I would expect it was an attorney, was not aware that there was no provision to restore a liquidated IBC.
Yes, yeah. They may have been thinking about the old legislation, but are looking at the amendment.
Yeah, that's still not too good.
No, but hold on, let me see if I have it. I did find something. Oh, I don't know if I have it. I think BVI just amended its legislation again. They made more recent provisions to their Companies Act.
Oh, okay. I saw, I mean, I think the judge also noted that no wonder the BVI is such a successful or prosperous financial center, and gave the comparison
Mhm.
of how many IBCs they had incorporated there as opposed to ours. You know, making mention of the fact that our laws do not properly provide for the administration and ongoing success or whatever you want to say, continuation of companies.
Mhm. Because you're in this business, but you're not keeping up with the changes and the trends and looking at things to facilitate your clients.
Right.
So it's so sad to see that we're normally the trailblazers in
Right.
bringing out these new products, but just like we have the government buildings, no one maintains it.
Yeah. But I mean, who is responsible in the Bahamas to, I mean, I would think it would be some sort of, I mean, the Lawyers Association, for lack of a better word. One would have thought that some group would have gotten together to have this amended, push for it. I don't understand why nobody has addressed this.
5 years, I don't know.
I don't understand. I can't get it amended. I mean, you know, I just, nobody takes responsibility, really.
No. And 5 years is a long time. And then then people begin to complain because if a simple request such as that, let's say based on fraud or mistake, is going to
Right.
take long, it's you turn people off.
Absolutely. And like I said, I can't remember the details at all, but it was a very big case. Maybe a year or two ago, I remember reading in the paper where the same thing happened. And the twist of the story was how poor our laws were. And it was an embarrassment that, you know, the act had been amended and that whole provision or anything to do with restoring a company after liquidation was omitted. You know, so it's come up again more recently, and it's still, as far as I'm aware, has not been resolved.
No, it hasn't. And it's sad.
Yeah.
It's sad because even if you say the FCSPs, when they have conferences, one-day conferences by the BFSB, that can be
Right.
lobbied.
Yeah.
That can be lobbied right there.
Those are just little marketing waste of time. One day things. Nobody takes note of anything. That's not, I attended a dialogue at Margaritaville a couple of months ago. There was no dialogue. It was a monologue of Halkitis and Brian Pinda, whatever, just saying what, repeating the same stuff that one banker pointed out was the same thing that had been said 5 years prior in one of a similar presentation, and it was supposed to end at 5 o'clock. And I think 5 minutes to 5, they opened the floor for any questions. And to me, that is not a dialogue, because by that time everybody was ready to go.
Oh, yeah, yeah.
So anyway, I mean, I'm not just trying to talk gloom and doom, but it's very hard to, make any changes. That's in those forums,
Well, you have to find some kind of forum. Something has to be done.
Well, it's a legal issue. I mean, I don't understand why FCSP should have to do it when there's a bunch of lawyers and judges who I would
Yeah.
think have a little more clout.
Yeah, but I mean, they could, the FCSPs, because it's their business, they can even write to the Bar Association.
That's what I was looking for, Bar Association, right?
You can write to the Bar Association to bring some
And
attention to it.
You think that would be effective, huh?
No, but I mean, it
This
would
whole
bring it
court
on.
case didn't.
No, but I mean, in the Bar Association, they have committees for different areas of law.
Mm,
So they can draft something and they could send it to the Attorney General's office. See, someone has to, after they finish, someone has to watch it and push it
right,
to keep the momentum going.
right.
And when you
Yeah,
send it
I
to
hear ya.
when you send it to the AG's office, then you send it to the Minister for Financial Services. And then you copy the BFSP and all the financial corporate service providers. So it is on the radar. Everybody's aware of it. They see the importance of it. And in it, you also put the comparison of other jurisdiction, the competing jurisdiction that have the provision to show
Right.
them where you got it from. But if you don't do a concerted, consolidated effort, it's not going to move.
No, because I guess lawyers get fees by taking this to court.
Right. So that's why you go, right. So you go through the Bar Association where it is going to be lobbied by them for free.
All right, I'll take note of that.
Yeah. Because other than that, it'll be just what you said. Oh,
Yeah.
you have a matter, you want this to be restored. Okay, minimum retainer, 15,000.
Right.
Let's get started. When you finish, pay me another 10 and let's move on.
Yep. And they got their client, yet the financial area of the Bahamas loses a client and all their friends because they say don't incorporate a company there.
So it'd be like other products that we have. We start off the Trailblazer. We came up with it, one and only. We were number one. And then when we blink our eyes, we realize 10 years later, how we get down to be number 10? What
Right.
happened? Their laws have changed. They evolved. They listen to their participants. They see what is happening. They reach out to them and make the changes.
Yeah.
But we'll have to do it in reverse.
Yeah. Sadly.
So hold on, let me see. I had printed it so I'd have been able to read it without going through my phone. So BVI just came out in February. Prior to January 1st, 2023, if a company had been struck off for administrative reasons, usually the non-payment of government fees, the company could be restored by a simple process involving the submission of a form to the registrar of companies and the payment of outstanding fees and penalties. Under the old law, if the company remained continuously struck off for a period of 7 years, remember ours is 5, it was automatically dissolved and a different restoration process was required. The amendments of the BCA, which came into force on the 1st of January 2023, alter this process. There will be some transition arrangements in place until July 1st, but it is important for BVI company directors and shareholders to understand the changes taking place. So from the 1st of January 2023, any company which is struck off for administrative reasons will only have 90 days to make good on all outstanding fees and penalties and be restored. If it fails to do this, the Registrar of Companies may publish a notice in the BVI Gazette, which has the effect of dissolving the company. The transition arrangements apply to companies which have been struck off before the 1st of January 2023. These companies will be automatically dissolved on the 1st of July 2023. The importance of restoring struck-off companies to the register is to avoid dissolution. Once a company is dissolved for having been struck off and not having repaired its position within the 90-day period, the process for restoring it is more complicated. So although struck off and then dissolved, the company can still be restored to the register by the Registrar of Companies under the newly amended BCA. This is a welcome simplification of administrative strike-off and dissolution. Any applicant should be aware of the criteria to be met before the Registrar of Companies will restore a struck-off and dissolved company. The application for restoration must be made in the approved form, and the Registrar of Companies must be satisfied, 1, that the company was carrying on business or was in operation at the date of a striking off and dissolution. A licensed person has agreed to act as a registered agent. 3, the registered agent has made a declaration in the approved form that the company's records have been updated as required under the Act. The company has paid the restoration fee and any outstanding penalty, and the registrar is satisfied that it would be fair and reasonable, you hear those words? Fair and reasonable for the company to be restored to the register. If, following the striking off and dissolution of the company, any property of the company has vested in the Crown, the financial secretary must signify to the registrar that the Crown's consent to the company's restoration. Alternatively, the applicant must show that the financial secretary failed to respond to its request for the Crown's consent to the restoration within 7 days of being notified of it. An application to restore a company that was dissolved subsequent to being struck off must be made within 5 years. So, you see what I'm talking about now, Denise? Everybody is moving progressively.
Yeah, I see that.
Okay, so
They have,
go ahead.
so they only have 90 days after a company's been struck off in order to restore it?
Yep.
So it went from 7 years to 90 days?
It says here where it remains. It's okay. After 7 years, you're automatically dissolved. That's like prior to. So now with the new legislation, it says if you're struck off for administrative reasons, you only have 90 days to make good. And if you fail to do so, the registrar will publish a notice, and it has the effect of means that the company is now dissolving.
That's interesting. And under our Companies Act, a company can stay on the register for 20 years.
Yes, yes. Mm-hmm. That's not the only part that that's not the only thing they did. They said restoring companies after voluntary or involuntary liquidation.
Right, so that's to avoid it having to be brought before the court. Is that right? That's simplifying the process?
Yeah, so restoring a company which has been liquidated voluntarily or by court order is much less straightforward in the sense that it involves an application to the court. The act has also been amended as it relates to this area. So in order to restore a dissolved company, like what we just did in Soothsayer, the person making the application to the court must have standing, but we know that. The categories of persons entitled to make the applications have changed. They are the Attorney General or any other competent authority in the BVI, a creditor, a former director, a former member, or a former liquidator of the company. A person who, but for the company's dissolution, would have been in a contractual relationship with the company, or it can be a person with a potential legal claim against the company, or it can be a manager or trustee of a pension fund established for the benefits of the employees of the company, or any other person who can establish an interest in having the company restored to the register. So you
And
see, they
our act only provides for a liquidator because at the point, once a company enters into liquidation, the directors no longer have control or no longer have any powers, and they all lie in the liquidator. Is that right? I think.
Yeah. Uh-huh.
And if I
Like, so-
recall from that
Go ahead.
case, it said that why they brought it before the Registrar General initially is because once a company is liquidated, which I was not aware of really, that the Registrar General can restore it if there was any sort of fraud involved. Is that right? Is that what that case said that you read earlier?
No, fraud goes to the court. The court has inherent jurisdiction for fraud.
So why did they apply to the Registrar General initially? And how could the Registrar General even enter into any sort of decision if they had no power to restore it at all? I thought that case said that they only would be able to restore it in case of fraud. And because that would be the only link as to why the initial application was presented to the Registrar General.
I can't recall if the Registrar General has that authority on fraud.
I don't recall either, but that's what I thought I had read, and that is why, like I said, they refused to restore it and said that it was not, because no fraud had occurred. Because again, they should have just said, we do not have the power. Sorry, I have a dog that barks at everything.
Okay.
The power to why didn't she just say she doesn't have the power to restore the company after liquidation? What I don't understand that.
Yeah. Denise gone?
No, I'm here. I just had to mute it so y'all didn't have to hear the dog barking.
Oh, he's not that loud. See, apparently they say this went on for a very long time. It doesn't give a lot of information in here as to what happened at the registrar level. Because all it says is that in 2017, they applied to the registrar to restore the company. And they had an affidavit from Mr. Rooney. And when the plaintiff made the application in 2017, they were under the mistaken belief that the application was straightforward. And the application had been contested, resulting in it being lengthy, protracted, and expensive. And the registrar had opposed the application on two grounds. One, that under the act, an IBC which has been dissolved cannot be restored to the register. But the court can't do it under its inherent jurisdiction. And the court can do it when it is based on fraud. And two, she was saying that the parties to the matter were not the proper parties to bring the action. And so she was saying they have no standing. So if she's under the view that the parties who's bringing the action don't have the proper, they're not the proper persons to come, then the matter doesn't move.
Yeah, okay, I see. So the Registrar General was involved because even though the liquidator joined in the action, they still didn't think that it should have been restored because they did not believe that even though the guy at Credit Suisse, the investment advisor or investment person, he had admitted that he had committed fraud, as well as but I think she said just because it was ongoing, the case was still ongoing.
The case is still ongoing, right? And don't forget now, when they went before the Registrar General, the liquidator initially was not a party.
Yeah, I recall that. But I mean, the only other party at that point would be the beneficiary of the assets via the trust. So I mean, I don't understand why they would how they could roadblock people. But anyway, that's my
Yeah,
personal.
they should have. Yeah, she should have. When the minute she got the matter, she should have just referred the matter, just to tell the consul that this is a matter that should go before the Supreme Court.
Correct, which the council should have also known too, which I said
Yeah.
already.
Mm-hmm. That's what they should have done. Send it to the proper place one time. Have the hearing, but it would have been short.
Right. Anyway, I guess it's a lesson. I'm not sure, but anyway. All right, I don't have any more.
Anybody else have comments? Because they were all so quiet.
Just
I
one
am shut up.
question. Oh, no, just one question further to Denise's point. So what then happens to the employee who, I guess, acknowledged the fraud?
Oh, that's criminal charges.
Right, and okay.
Yeah, criminal charges.
And that's in Singapore. They'll probably cut off his hand.
Yeah, that's criminal charges.
They rough in that
course,
section.
Right. And then of course, the beneficiaries are going to sue the trustees.
Well, I hope they are quick, because if that's Credit Suisse, that is no longer in that's now UBS. Anyway, the world turns.
Yes. It's things move fast. I agree
Crikey.
with you. Because if this matter is still in court, like you say, I don't know
Yeah,
what's left for them. Because this
dog
is what,
to dinner.
right, 29, 20, yeah, it may still be in court.
Yeah.
Mm-hmm.
Anyhow.
Yeah.
Copy that.
So Denise, if you're interested or anyone is interested, I can send you all this latest update that came out on BVI and the changes that they made.
Yes, that would be good. Thanks.
Okay. Yeah, I'll send it to you all. It's because this article was written, February the 20th, restoring companies in BVI, recent case law and legislative changes.
That's something else that would be nice in our jurisdiction. A notice of when legislation has changed and how it's supposed to be applied.
Oh, well, the law firms normally do it. The top tier law firms, if you
Mhm.
frequent their websites,
Right.
they bring out notices as to legislation as they are changed.
Okay.
So the first thing you have to do is you have to follow what's in the news or in the newspaper. When you hear them say a piece of legislation, like I think right now the two pieces are the procurement bill and the public finance management.
Right.
bill. Those have already passed through Parliament and then now in the Senate.
Yeah, I mean, I get those notices, but I mean like amendments. I don't recall.
Amendments, they
Seeing-
do those too. Yeah, they do those too. If
Really?
you read it, yeah, if you see, that's one way you could look at it, either from the on the radio or in the papers, or you go to the government website, on the government website where they have laws, legislation and amendments. You click on, they have a table of all of the laws that are being that are actually bill or amendments to existing legislation. And then the top tier firms, law firms, when they make these changes, like the recent changes in real property tax and VAT and stamp duty, when they made those changes, they wrote articles on those and how it affects
Really?
business. Yes, they do.
Because I Google that all the time, and all I see is articles from 2015 on those top
No,
tier
they
websites.
There are things on the websites.
All right,
Yeah.
I'll take a look again.
Yep, they're there. Follow the top ones: Graham Thompson, Harry B. Sands, McKinney, Brankoff, and Hughes. I think Clinton does sometimes, so they're out there. 'Cause
Okay.
that's how, don't forget, they can't advertise. So that's the way in which they drum up business, by showing
Yeah.
you that they're on top of the changes in the legislation.
Okay, well, we went to a top tier law firm for an opinion on the changes to the VAT Act and the Stamp Act. And we had to send it back about 6 times for him to amend his opinion for it to be accurate.
You mean with the recent amendments?
Yeah. It was, and even Cesra. Cesra is awful. You can't get any guidance.
Yep, agreed.
Yeah, I mean, that whole thing is ridiculous. And then they're supposed to be amending that, but the things that they need to amend, they're not even amending. And they acknowledge that in conversations, but it doesn't matter. We could stay on the blacklist.
Oh, God. I thought they said we were coming off by the end of the year.
That's a long time. Our clients are being affected by that. Because they're Bahamian resident companies. They're having difficulties getting services from their banks because they're Bahamian companies whose accounts, who's the account holder, because it's from a blacklisted jurisdiction, they are de-risking and they don't want to get involved with any services.
Mm.
And the end of the year is a long time, but that's just when it's going to be brought for another review is the end of the year. That doesn't guarantee that we are going to not be blacklisted since the portal still has not been revamped or amended, and it's still in the trial phase. But anyhow, yeah, I don't know. And it's all because of our CESRA reporting or the lack of being able to obtain data to share. That's why we were blacklisted.
Yeah, but I mean, when I look at Cesra, how many clients do we really have that fall in that category?
Every client, every Bahamian company has to report. There are not very many that are included entities, but even those that are included entities still really don't know, dependent on what their relevant activity is, what sort of substance, what sort of requirements, what they need to have in the Bahamas in order to comply.
Right.
So, and like I said, we got an opinion on that, and it's still clear as mud.
Yeah, but the legislation, when you read it, is clear as mud.
Absolutely. They love that word. What's that word? Not sufficient, but not relevant. But it's a very broad term that gives no guidance whatsoever, and you cannot get any guidance whatsoever. But I'll tell you one thing: a couple of our clients, they came in to do an inspection. So we'll see what happens.
The clients?
No, the Ministry of Finance, the competent authority came in to inspect the files of an included entity.
Yeah, they're going around to, I guess, I don't know if it's all of them, or if they've selected some, but they are going around asking questions about CESRA and reporting and those kind of things.
And also they want all documents to be provided to them, basically replicate the company's files. And in sitting with them, there was an auditor, an attorney, and I can't remember what the other person, maybe an accountant. They were not even clear on CESRA. We had to point out a few things that they asked for, and we're like, no, and point out to them. And then the attorney tapped and said, no, that's not needed. That doesn't apply.
Yeah, so I think it may be the pressure, or based upon the questions that they asked the government for what they needed, and they decided that they needed to I guess formulate and go out and see if they could get answers to those.
Yeah, I guess I don't know, but we'll see. We will see what happens. But to expect companies that are only involved in intercompany financing to set up an office here and to have board meetings here, all board meetings here, and to have directors in the Bahamas that have capacity and knowledge of the company's affairs to make decisions. I think it's bizarre. I don't understand how this will all work. I think we're going to have a lot of loss of business.
Yeah. I think one of the problems that we have is
Mhm.
how we approach these international matters.
Correct.
We do patches instead of going back to the drawing board and say, okay, this is our model. Now, this is the pressure that's on us. How can we change our model to fit in? Not
Right.
draft a bunch of legislation that don't fit into the model. So now you have this big piece of legislation and no one can tell you what it means. I've read it twice. I don't know what they're talking about.
Twice. I've read it about 50 times.
No, they don't make no sense. The second time, if I read it the second time and I don't understand what you said, I might as well stop. I don't know what it is.
Oh, for sure. I mean, yeah, but I don't have that option because I'm responsible for substance reporting in my office. So I have to understand it as best as I can. And what we've been through is really, it's unbelievable between Inland Revenue and Ministry of Foreign Affairs fighting with who should do what, being bounced back and forth. This is going on 2 years. I'm trying to get something resolved on the portal, and now it's just nobody's even answering.
No, because nobody knows.
No. I mean, it's all good and well to implement these, like you said, great pieces of legislation, but at the very least, educate let somebody understand its application and disseminate that to the public.
Yeah.
You know.
Yeah, because to me that's just gobbledygook. I can't figure it out.
Yeah. No. Anyway, that's my Cesar rant.
Anybody else? I see Valencia was making some comments.
Yeah,
Yeah.
no, I agree with Denise's points. Just not clear, I guess, as to, what it entails, what the CESRA is all about. The reporting, I know, in some cases I think we had a client who was saying the underlying client should not have been reported. Some persons are saying if you hold 10% or more, then you have to report. And I guess we have some other report where everyone is reported. So it's still not clear. Still not.
Well, it's not clear whether you're supposed, I mean, in certain areas, they reference the beneficial owner, yet the portal request for the shareholder
Directed.
and
Okay.
and providing information on the shareholder's tax residence really has no bearing when the shareholder for some of these companies are a nominee company in Panama. That resolves nothing, because if they're supposed to be reporting that to any authorities, they're totally missing the point, because the actual beneficial owner is the person who you should be looking at with respect to tax residence and reporting.
Yeah. Yep.
But you
You know.
realize, right? But you realize that most of these structures, and this is why the structures are being created, is for anonymity. So even sometimes, like if you take it from the compliance standpoint, even if there is an ultimate beneficial owner, a name of Joe Smith, that doesn't necessarily mean Joe Smith owns that company.
Oh yeah, I mean, we totally put in the shareholders because that's what it asked for on the portal, and that's what we put there, So foundation is the Panama Foundation is the shareholder, the tax residence Panama, So, but anyway, the good thing is at the end of the day, the onus, the reporting onus is on the directors.
Yep.
So we are only facilitating the reporting, and we get the directors to sign off all the information that we, enter into the portal.
Right.
That's on them.
I hope the provision within the contract, the liability is tight.
Oh yeah. This is the risk appetite in this section ain't too high. We're the indemnifying kings and queens.
Yeah, you have to make sure because I don't know, that piece of legislation makes no sense.
No. No.
No. None whatsoever.
Anyway, yeah.
But you all have to lobby.
Yeah, I could do that on Monday.
Yeah, seriously. No, but especially if you don't want the industry to die, because trust me, it's just like running a race. You know what I mean? When the competitor, your team is always coming first. Now there's a new year. You see them come in and they beat you. The next year, another setter from another country beat you. All of a sudden, you're no longer number one, you're number 5.
Yeah. Yeah, I mean, I think that's happened, eh? I mean, look how long I came into this industry, I think in 93. When I came here, everybody was complaining about the registry and nothing has changed. 93, that's 30 years. That's 30 years. And my a coworker was a member of the what do you call that? Doing Better Business thing? That committee? That
Yeah.
was just a waste of time because no changes were made. And that committee was supposedly formed to try and address issues in the, in this field, in this section. And nothing sector and nothing happened. And the feedback they got as to why nothing could change was profound. So it just makes you want to give up. Like it's going to take a whole nother generation or two for any changes to happen because of the, unfortunately, the mentality.
Yeah, but you gotta fight, because I think sometimes the persons who are at the forefront, like the persons who have to make that decision to say, yes, let's make this happen, let's push it, they're not in the area. When I say not in the area, they don't understand the practicality of what you do every day and what it means.
Well,
It's just-
that's why this whole committee was formed, to get the feedback from the applicable sectors as to what they experience and how we could do better business in the Bahamas. And nothing came out of it. And these are big players.
But that person has to be a person who has power within the community.
Well, I think it was in front of, I mean, it was headed by, I forget who, but I mean, right down to the Registrar General said there's nothing they can do. They understand that their employees are subpar, but they're not allowed to fire them. They are not given any extra funds to raise their salaries, and etc. So this is what you get, and nothing could change right now, is basically what they said.
And that don't sound true to me.
The Registrar General said that they called
Right.
her in. They called her into the meeting, and that's what she just said straight out.
Oh, sounds like a cop out to me.
Well, I mean, it sounded very believable because nothing has changed at the registry.
They didn't try to do anything.
Well, I mean, why wouldn't they? With all this feedback over the last 30 years and all this criticism, why wouldn't they do anything then? I think they're being stopped because of nepotism, a combination of everything.
Wow.
And I mean, that's what she came right out and said. That's what she came right out and said.
Bad.
Yeah.
That all they could
Yes.
do is transfer them to another department,
Oh, no.
Mhm.
and they cannot attract anybody above what they have now because of the pay that is being given.
Hmm.
And that
Yeah.
sounded like it made sense to me,
Hmm.
because that's the only reason I could believe why there haven't been any changes.
Hmm.
And that registrar, she left,
Hmm.
and there was a new one appointed, of which we didn't get notice of either. I only saw a different signature on the
Okay, but-
certificate.
Uh,
Anyhow, yeah.
I'm sure the current minister the current attorney general he's trying his best to make a difference because he realizes it because it's something that
He's familiar with, yeah.
he knows. Because if
Yeah,
he
well,
was
that dialogue I mentioned to you, somebody stood up and said it. And they said, you know, our hands are tied. We can't even do business because of the state of the registrar general. And
Exactly.
and he acknowledged it.
Mhm.
But I mean, all he could do is shake his head and hang his head because he knows that that's been an ongoing thing for over 30 years and still nothing has been done.
And that's why he say he's trying to change it now to do the necessary changes to get the new software, all of that. So hopefully he does it in the next 2 years and has everything in order.
Yeah, only thing that could change is the location. It could go from the old building to
Come
the
on,
new one across the street.
Oh, gosh.
let's be optimistic. Let's see
Oh,
it,
gosh.
because it impacts it.
It impacts business, yeah. It hinders progress.
And
It's embarrassing, really,
Sad,
to the
yeah,
client.
it's really sad.
but
Yeah.
remember now, this is what he does on a daily
Wow.
basis. He
Yeah.
was not in power. So I think if he has the power to do it, he's going to do it.
Hopefully, because you can't even get a phone answered. Like we tried calling,
They don't work. They
emails.
haven't worked
Yeah,
for
it doesn't. Yep,
years.
yep. It's really
So
sad.
he understands, he knows the importance of it. So let's see if he'll do what he has to do. I mean, they have so many other competing priorities like building airports and all the rest of that. So let's see if he can get something.
Hopefully,
Hopefully,
yeah.
I understand the cries, but we'll have to see.
Yeah,
Mm-hmm. All
we
right.
could put a bet on it. Let's put some money on it. I need to cushion my salary a little bit. Yeah. Anyway,
I will definitely send an email to you and Valencia. And this that it has been done and things
Oh,
goodly. Now, whether that's 5, 10, or 15 years,
yeah. I'll be in my rocking chair looking out my retirement, what you call them thing? Retirement home? Old age home? When you send me that. Anyway, all right. So
All
what's
right.
the plan now
On what?
for this class? What we gonna do now? Final exam is waived, and because we're just all such great people, we passed. Is that right?
Oh.
That's what I heard.
Don't even try.
you're
When I
good.
heard plan, I was ready to unmute my mic.
And listen, oh, finally.
Hope springs eternal. You said to be optimistic. What's my optimism right now?
You all.
I don't waste my optimism.
I'm gonna send you all another case. It's called
Oh my God.
Hold on, man. Stop dying.
Okay.
This is for your information.
Okay.
Okay. This is an IBC Act again. This is a company that was unable to pay its bills. So it went before the court. So the petitioner is a company called LS Enterprises, and it filed a winding up petition in November 2019 for an order for this company called Okeanos Operating to be wound up on the grounds that it was insolvent and unable to pay its bills. So LS Enterprises petitioned as a creditor of the company, and the company was indebted to them for $12 million. So LS Enterprises had loaned to Okeanos this money, $12 million, under 4 facility agreements. So by a director resolution and a member resolution, both dated the 19th of November, 2019, Okeanos admitted its inability to pay its debts and declared insolvency. And the company's insolvency was subsequently confirmed in a report by the provisional liquidator on the 25th of May, 2020. So this company is in Freeport, and due to Hurricane Dorian, and all of the island-wide power outages for many days, and the home structures were destroyed. Substantial amount of water and wind had penetrated the company's premises, and it caused them major loss and damage, estimated at over $2 million. So in the immediate aftermath of Hurricane Dorian, the company's premises, operating facilities, and equipment were not functional nor functioning. Let me see if I can tell you what this company used to do. It was to do stem cell, I think. So they tried to mitigate their loss and damage by moving their equipment and supplies to a climate-controlled storage, and prepared the company's operating facilities for mold remediation, but they were hampered by the landlord. He instructed the company's staff to cease and desist from doing any activities to the building. So after that, the company business ceased and they couldn't resume. So they issued a notice of lease termination on the 25th of October, 2019, and the landlord disputes the termination. And on the 30th of October, 2019, they went to court. The company filed claims for damages with its insurance agents for losses arising out of the hurricane, but did not receive the majority of the insurance proceeds. So then the company defaulted on the facility agreements with LS Enterprises, under which it had secured these substantial loans. And so it had insufficient funds to secure alternative lease premises. And so LS Enterprises demanded their money. So Okeanos admitted that it couldn't pay its bills that was due to LS Enterprises. And so, due to the winding up petition, the company is insolvent. And so LS Enterprises is before the court now for an order that Okeanos be wound up on the grounds of insolvency and that an official liquidator be appointed. The provisional order stayed the landlord action. The provisional liquidator submitted the report, and in the conclusion, among other things, the liquidator said that based on examination of the company's internal records and its unaudited balance sheet, the company is insolvent. It has unaudited liabilities of $13.2 million, and that exceeds its unaudited assets of $5.6 million, and its cash balance of $335,000. And so it has unaudited liabilities of $13.2 million. And so the jurisdiction of the court to make an order for the winding up of the company is provided for in sections 185 and 186 of the Companies Act as amended. The insolvency ground is founded at 186C, section 187 and section 188. And these terms, just and equitable ground, is founded at Companies Act section 186E. And the relevant rules for procedure for a company's liquidation is Order 3 pertaining to winding up petitions under the company's liquidation rules. So pursuant to section 185 of the Companies Act, the court has the jurisdiction to make winding up orders in respect of an existing company, a company incorporated and registered under this act, a body incorporated under any other law, and a foreign company that has property in the Bahamas, is carrying on business in the Bahamas, or is registered under Part 6. Section 186 of the Companies Act lists the circumstances in which a company may be wound up by the court. And section 186 states a company may be wound up if the company is insolvent or the court is of the opinion that it is just and equitable that the company should be wound up. Section 187 gives you the definition of insolvent, and section 188 states that a company shall be deemed to be unable to pay its debts if it is proved to the satisfaction of the court that the company is unable would pay its debts. So pursuant to section 186C of the Companies Act, a company may be wound up where it is insolvent, and by section 187, a company is deemed insolvent. And so if I go to the end, the judge says that as a result of the extensive damages sustained by the company due to Hurricane Dorian, the company's business has ceased. It has no means of generating revenue in the foreseeable future, or to borrow funds for its operations, or to pay debts as they become due. The company's insolvency has been established. As of this date, the company has failed to settle its indebtedness to the petitioner or compound it for the satisfaction of the petitioner at all. The company is unable to satisfy its debts now due, and as others continue to fall due, the directors of the company informed the petitioner that it was insolvent, and the provisional liquidator has confirmed that the company is unable to pay its debt to the petitioner, and that the value of the company's liabilities exceeds its assets. So the court asks the counsel if they would prefer to have what they would call a soft touch provisional liquidation. And soft touch liquidation means that you would leave the provisional liquidation in place and you would offer protection against individual creditor actions and enabling some breathing space so you could do some kind of like restructuring of your debts. But the company decided that they didn't want that. So the court concluded that balancing the facts with the applicable legal principles and the overwhelming interest of justice underscored the grant of a winding up order and the ancillary relief as prayed by the petitioner. And so the winding up was approved by the courts. So that one was due to Hurricane Dorian. So this case would have started during the pandemic. Oh, yeah, the business of this company, Okeanos Operating Company, it was in the business of regenerative medicine using stem cell therapy. They had highly trained and licensed medical doctors, together with nurses and technicians, deploying advanced technology and equipment. Because they used to do stem cell for cancer patients. So I'm going to send that one to you all. All right. So now so everybody could start talking.
Yes. Number one.
The final exam has two parts. Part A and Part B. Part A has 10 questions. Part B has 20 questions. You can answer 5 from A, or you can answer 3 from A and all of B.
So what's B?
B is the multiple choice.
Okay.
So let's go.
So if we don't do the multiple choice, we have to do 5 of 8?
Yeah.
Okay.
Yes. All right. So
That doesn't sound like a deal.
that was
Man,
the
that sound delish.
isn't that what you agreed?
Yeah, that's it.
Yes, I'm only talking caca.
Okay. All right. So one of the questions, do you remember the case we read about the gentleman and his wife where he put his properties in a company?
The one with the
The
with the
divorce
second wife.
one?
Yes. the one.
Anita?
Mm-hmm. So I have a question on that.
Which one? No, I don't know what you're talking about. Divorce is why? You mean the first one in the first chapter?
Chisholm. No.
Chisholm.
Oh,
The pasta.
yeah, I know.
Okay. Yeah, it would be similar to pressed.
Well, that clarifies it.
Yeah, Chisholm. See, she remember Chisholm, right? So I wrote the question similar to pressed in terms of the court piercing the corporate veil and taking a different approach in matrimonial matters. So that's part of a question.
Gosh.
The second part, this is not difficult. The
It's not
sec-
difficult then.
No, it's not. That's only worth 10 points. That does not sound difficult. The next one, it has to do with other case, the one that Denise loves. It had to do with the diving case.
That's my case.
Okay, yeah, but she liked
Bahama
that.
divers.
Yes. So there's a question on the Bahama divers, and it's talking about, the question is for you to discuss the approach taken by the company, the owners of the company. Easy question, easy peasy.
So, attached to this exam is could be a copy of these cases.
No,
Good Lord.
I guess we just gotta read the case and remember what it was about. A little summary, right? A little
Exact-
summary of the case.
summary, you're not writing 2 and 3 pages. I've already told you what the one on Chisholm is about. It's the use of a company to place the assets. And you're referring to the Chisholm case, so you know exactly what he did. If you don't know, read the case and you'll see what he did. He put it in, remember?
You
Maybe
put it in
before he
him
got
and his
married.
kid's name.
Him and his kid's
2
name.
weeks, 2 weeks before the wedding.
Exactly. But then she was doing a lot of the operations for the company after that.
Yes, she was.
Yes,
She was basically managing the company.
yes. And he tried to
And
short.
mowing his lawn.
Exactly. So that's like in Press versus Petrodel, the court said they were not piercing the corporate veil. But he had to be equitable towards his wife. She was a sick woman. And then when we did the Kramen case with the diving, remember we discussed this. When we said, what did we say was the key thing in our view when we read the case? What was the key thing we said went wrong in that case?
He should have said something about it when it was in Florida. He should have appealed the case in Florida.
Yeah, they should
Yeah,
have appealed
should've
it.
brought it
Right.
here. Yeah.
That is a
It should have stayed.
right.
Shouldn't even try it here.
There's
Why
no,
remembering these things now?
well, you better remember it now and write it down. So those two go together. That's one question.
Oh, my God.
But that's
That's
your
one question.
Wait, you
Yeah.
mean Chisholm and Prest is one, those two cases go together, or you mean Chisholm and Kramen or whatever is one question?
Chisholm and Kramen is one question. Part A, part B. Two
Mhm.
separate
Wow.
one.
Hold on, who's cramming again?
Bahama
divers.
divers.
That's the
Dive-
Preston people? Oh, no,
No.
the Bahama divers.
That's Bahama divers.
Okay, okay.
So
That's
that's not,
sneaky. That's two questions. How are they related anyway?
they're not.
Oh, how they could be A and B under one question?
So
They're not.
that's two different questions. A and B is two different questions?
That's
Yes.
A and B of one.
Of one question.
One question, parts A and B.
So that's
Yeah.
two questions.
That's
No,
what I said from
No,
the beginning.
one.
That's what I'm saying.
it's 2 parts in one. What did you say?
They sound tricky.
It's not.
Mhm.
Yes, because
No.
they could be number one, A and B. So you're really answering two different questions.
That's what it is. One question, A and B.
Mm.
Who's Valencia? It's not that.
Right.
one.
Swinging us. They sound like a swing move.
It is
They
not.
sound like out of the 3 questions, it really 6 questions.
I mean, she worked for government.
Parts.
Let's go.
Oh,
I know for that one, you got that. You all know that one. So I'm not worried.
Yeah,
So
but
part A,
yeah, anyway, okay.
part A and B total 10 points. The entire first question is totaling 10 points, or 10 for A and 10 for B?
10 for A and 10 for B.
Okay, thanks.
That's a giveaway question.
In your mind.
I know because I watched the comment come when we discussed the case. I said, you know what? Out of all the cases, let me put these two here. They'll love it.
Yes, we love talking about it casually, but to present it on an exam, using, all the words you want to see, although we don't know what those words are because we didn't get our first exam back. But anyway, to present it properly is different. We were talking about how mean he was. We could say that on the exam,
Of
how
course.
stinky he was,
Yeah.
but we won't get any points for it.
But at least it'll show you remember.
Oh yeah, I talked about that to people.
Oh Lord, you talking to my business?
It's public
Public
record.
knowledge.
public,
Yeah, just
yeah.
say public knowledge.
You
I
didn't
ain't
call-
going to his. Oh yeah, I'll go to the Bonefish thing now that she owns it down in Acklands or Knowles or wherever that was.
Yes, that's good. It's a good one. It's out. All right. So the next one has A and B also.
Oh Lord,
What happened?
they sound like this done 4 questions already out of the 5,
Remember
which is
now.
really 2.
Now, when you see A and B, that doesn't mean that you're writing a page for A and a page for B. That's why it's called A and B.
That's actually I'm long-winded. I able to write 3 pages for A
So
and
you
then 3
won't-
pages for B.
No.
I have to
Okay.
plead my case.
Plead your case then. This one has 2 parts. One part is on the regulatory and statutory compliance requirements, and that could either be for a CAC or an IBC. And the B part has to do with the vulnerability of the services and products that we offer as FCSPs.
Can you repeat it again for the last time? You said the vulnerability, who?
The services and products
Okay.
that we as FCSPs. Then I gave you all a very easy question. It's a scenario.
Can I just ask something? I'm so sorry. I thought it was your internet. I was blaming you and it was mine. I shut out after you said question A is on regulatory and statutory requirements. I didn't hear anything after that. I'm sorry.
Oh, either for a CAC or an IBC.
And either, you're
Um,
saying either one then?
The one,
Either.
yeah.
I need to put that. Okay, I'll put that. Then.
So this is short answer too?
Yes, that's part A. Part B is you need to discuss the vulnerabilities of the products and services that are offered by FCSPs.
The vulnerabilities and what?
The vulnerabilities of the services and products that are offered by FCSPs.
When you say the regulatory and statutory requirements, how do you summarize that? I mean,
Ju-
statutory requirement, you mean starting from incorporation going on?
No, this is statutory and regulatory compliance. Remember that was unit what, 9, 8?
You
What
mean
is re-
last class?
Yeah, what is required by statute for a CAC or an IBC?
Oh, you mean filing those annual things?
Yes, and they must have the memo and arts, register of directors and officers, those things. It's just a list.
Oh,
So you can put it right on the side. It's a list. B,
So you have to speak to a IBC and a CIC, sorry?
either
Either.
or.
or
Oh, either. Okay, okay.
Go in the room, Kiana, in the room.
And so section B refers to risk?
no. The vulnerabilities of the services and product offered. You don't remember that?
Well, I mean, I thought that meant it of the risk involved.
Yes, the risk involved. And other things.
Okay. But that was our risk chapter, right?
Yes. And while we're on risk, let me see.
Gee, there's only 2 questions and how many you say? Where I wrote that?
Five. No need to panic. Okay, so I have a question here where I have given you an excerpt of a company's corporate governance rules. And you are required to explain why it is important to have such rules. And also talk about enterprise risk management and the process of a risk assessment. That sounds easy, hey?
No.
Sorry, Ms. Archer, the
Ms.
last
Arthur,
part,
can you
please.
repeat the last two,
Yeah.
please?
Talk about ERM and
Process of a risk assessment.
thank you.
That's an easy question.
That's because you're a risk woman.
Sounds like that's the one I'm gonna skip.
Yeah.
What
I'll put,
happened to
I'll put a line through that now.
what?
Nothing.
Don't give up so quickly. All right. The next question is a company is on shares. Oh Lord, I know Denise, you don't like shares.
I ain't skipping this one. I ain't tell you that. I ain't say no lie.
I don't mind IBC shares. Is an IBC question?
No.
Oh, that's not fair.
Well, you could make it one if you want. It could be anyone, but anyhow. 2 directors. The appointed person to the board. The articles require how much shares they can hold. And the articles also state how long it takes for a new director to pay for those shares. So you have to explain what needs to be done in order for the new director to buy those shares. And you have to also talk about the procedure if a company buys an asset above the value of the shares that they've exchanged for it.
How we know the answer to that? We covered that? I don't remember covering that.
If you purchase an asset and it is above the shares, what is that called?
Stupid. I don't know. Excess
Premium,
capital,
yeah,
I don't know.
yeah.
You know,
I
it
don't
was,
know.
yeah,
Wouldn't it be premium, like above, like above
Premium.
the authorized, yeah, above the par, something like that?
That would be increased capital.
yes.
Okay, increase.
Was that the answer?
Yes.
Oh, okay. Oh, so we need to explain what needs to be done if they decide on doing that.
Yes.
Okay.
Easy peasy Japanese.
What, no, I'm lost on that. What did you say?
It's called
You
a
said
share
if, called
increase.
what?
It's an increase in capital.
You mean an official increase in capital, like when you increase the authorized share capital?
No, that's why you put it under share premium.
I don't get that correlation. Okay.
Because you
So
like,
the question is, you said that if somebody purchases shares of a company in excess of their value,
they purchase an asset, and in purchasing the asset, they exchange it for shares in the company. But the actual asset that they purchased was more than the value of the shares.
gosh,
So there's a premium.
I don't understand. You mean, so I'm not trying to get guidance for this question at all. And if that's what if it's too much information I'm asking, but what, could you give me an example of that? I don't understand what you mean. If somebody purchases an asset in exchange for shares of a company, like what, a building?
Yeah.
Yeah,
So
or property, yeah.
property, building. So let's say they say that we're going to purchase this building and the cost of the building is $10,000. But the
Right.
shares that you're offering for it is only worth $8,000. So there's a premium of $2,000.
Oh.
Yeah.
And we have to explain what?
What we just finished saying.
Oh.
It's not long, it's very short. That it is an increase in capital. And it's booked to share premium.
Wow.
And then the other one is where there's a new director. And he's the articles say that you have a required period to purchase your shares. And you now have to decide, how is he going to buy these shares?
Can you repeat that again, please?
The articles state that directors have to hold a certain amount of shares. So they have a new director, but the new director say he can't pay for his shares. What has to be done?
So you said that's like part A of that of question number 4, and the other one about premium and increasing capital is part B.
Correct.
So I have a question. So pretty much all of the questions have a part A and part B.
No.
Oh, but it's like
So far,
2 out
are
of
we
them
on
so
4?
far. No, 3 of them so far out of the 4 have a part A and part B, I think.
Yeah, but that one I just gave you is very, very short.
Okay.
That's not long at all. And the one I gave you on statutory and regulatory compliance for a CAC or IBC is just a list. That'll take you 2 seconds once you've memorized that. The only time you may probably have to think a little bit if you didn't prepare would be on the vulnerabilities of the products and services.
Okay.
Yeah, so it's not that difficult. The one on Chisholm and Cramin, if you've written your notes on that, you know exactly what to say. Those aren't long either. So remember when we did the case with those Africans? When
Okay.
and when they brought the matter before the court to make
Oh, you mean in the mine?
to make the parent liable
Yeah.
Mhm.
of care. I just want you to simply discuss the two basic types of duty of care that was mentioned in that case. Lord Justice Sales, Sales, he briefly discussed the two duties of care.
What was the name of that case again, please?
Vedanta.
Oh, I have that written here. I didn't know what I wrote it for.
What's the name? You spell it for me?
Vedanta versus Longovi. Right?
Yes, you're
Versus
correct.
who?
Logowi or Lungowi. Lungowe.
Oh, I thought it was Longovi. Lungowe.
Uh-huh. That's a question by itself.
So a question like that, like number 5, where it talks about a specific case, do you want us to write like a little background about the case or just answer the question?
Look where you go in. She said discuss the two basic types of duty and care.
Okay, no, I just wanted to make sure.
Oh,
Denise, keep up.
yes.
Up.
I
If-
feel chastised. But
If-
I just want to be sure because I gotta memorize this stuff for the exam.
Yes,
I don't want you to give any ideas.
No, I mean, if she can remember, she can put it in because when you speak about the duty of care, you're gonna have to talk about the case.
Okay,
Gonna have to say what happened, why this duty of care was so important.
okay.
Denise, you don't have to answer that one.
I'm not gonna be able to answer any.
That is- Don't listen. Yeah.
Fine.
Oh, gosh.
You must stop. Okay, so I have another very interesting question.
I thought there was 5 questions there.
No.
I
You
missed.
5.
I think
Pardon?
it's 10 and you choose 5.
Oh,
It's
okay,
10
okay,
questions, yeah.
sorry.
Right. Yes.
Okay, so I have a question on shares again and variation of class rights. So that should be a very easy question. And the next question is on winding up. One is about for you to explain about the life of a company during the process of being wound up. So you're talking about the roles of the different persons. And the next one is just for you simply to say the difference between a voluntary and a compulsory liquidation. Denise will answer that one.
You switching up the terms on us, so compulsory is involuntary, I guess, right?
You want me to change it?
You mean
I
to
like-
involuntary?
I like things to be
Yeah.
the same.
Okay,
Yeah, put involuntary.
Okay, all right. Have changed that one.
Hold on, you change the question, or you change the word.
Change the word.
Okay.
You
So
remember,
part A of that question is the process, the life of the company during the process of being wound up, and then the second part is the differences?
yes,
Or that's all one question? Okay, okay.
remember when we did that case ZRK Limited?
No,
No, ZRK, what was that?
Josephon and ZRK.
It wasn't here, that's downtown?
Yes,
That was last week.
Mm,
They wasn't here.
Okay, okay,
Yeah.
we weren't here, no.
that's when we didn't get the link.
yes. So, that case was a matter against public policy. So I want you to discuss the role of the company in that case and the fronting operation that was agreed to in that contract.
Sorry, repeat the last piece, Ms. Arthur. The fronting.
Operation
Uh-huh.
to that contract that they had agreed to.
Oh, okay.
The role of the company and the fronting operation. Remember, there's quite a few points we picked out with that company.
Mm-hmm.
Oh, was that what was in the paper not too long ago? With
Yes.
the Scans cafeteria people?
Yes.
Yeah.
Oh, about time they got some of those people.
Yes. We discussed that last week.
I remember, I read that in the paper,
Mm-hmm.
and how they exposed themselves by saying that the people didn't live up to their side of the contract, and then it was exposed that they were operating basically illegally with people with no work permits.
Mm-hmm.
Wow.
They exposed their own self.
Yep, they did.
So you said that case was called ZRK?
That is Tal Nimo and Yusufan and ZRK Limited. You should have that.
You mean it was sent to us?
Uh-huh.
Okay. I found that quite a few, I mean, some of our questions, I think at the last midterm applied to, like there was implication that we should know how contracts are governed. How we post that?
Now, when you say how contracts are governed, what you mean?
Like, I think it was Betty on the midterm that, how, the fact that she entered into a contract with the construction company. And she wasn't authorized to enter into a contract of that amount. A part of that question said, would they have to honor the contract basically? I don't know how contracts are governed. That's something we should just know on our own, huh?
Well, I guess, yeah, you should have an idea of how a contract is entered into and the terms of a contract.
I mean, as far as I am aware, a contract is binding, but I don't know anything further than that. I guess anything could be overturned in court.
Mm-hmm.
But yeah, I mean, that's just my general knowledge. But I just wondered if I had missed something, like, you know, how we supposed to know about contracts.
I think it's the first chapter we spoke about the companies and its torts and liabilities.
Right. But
Yeah.
but a tort is defined. I mean, I looked up the definition of a tort and she didn't commit a tort.
No, that wasn't a tort, but that would have been, it's a liability to the company.
I'm pretty precise, so I thought that only applied when a tort had been committed.
Tort and liability is whether or not you went outside of your authority.
Mm,
So I have a similar question on the final exam.
I bet. You like
Yes.
Betty.
This ain't Betty. This one has a different name, but it is about a CEO making decisions. I've given you an extract from the articles of association as to what he can do. And he has carried on some actions very similar to Betty, and you have to talk about whether or not the opposing party can enforce the guarantee. So I figured that was a giveaway question. But you all have so many to choose from.
You said that because it's similar to what we had on our midterm,
Yes.
but we don't know if we answered correctly on our midterm, Christine.
I thought we did.
You thought we did what? We haven't heard anything more about our midterm besides our score.
I have them right here. Hold on. If I thought that was a giveaway one, let me see. Man, I could ask Mr. Pratt to scan these to you all, if you wish. Want me to do that?
Yes, please.
Yeah, now that it has some bearing on the final for sure.
Okay, I could ask him I could give these to him and he could scan and send it to you all.
Isn't he on this meeting?
He probably not listening.
Oh,
Yeah,
maybe that's what's happening, because I think you asked him to do that first before.
yeah, he probably wasn't listening.
I
Okay.
called Mr. Pratt
Right.
on Monday.
I'll send these to him and let him send it to you. But I put something similar to that on the final for you.
Okay.
Okay, my next question. All right,
I have a question.
go ahead.
As it relates to, for example, number one, A and B. Once you're answering number one, you have to answer A and B?
Yes. Otherwise you lose.
Yeah, that's where I was kind of going with my question earlier.
Yeah, I'm trying to figure out if I only answer A over here, B over.
If you only answer A and you don't
Get
answer,
5.
you've lost 10 points.
Yeah, but suppose I answer a whole bunch of questions though.
Why would you answer a whole bunch of questions?
To try to get all the
Because you
answers.
might feel confident on something else, but maybe not like both parts of that question.
Because I was saying, since A is 10 and B is 10, suppose I answer a different B, that's also 10.
No, that's why.
I'm just trying to get clarity.
No, that's why the questions are written that way, to make sure that when you answer, the examiner gets a clear understanding that you understand all areas of the topic. That's why it's.
But isn't like, but didn't you say like number one, A and B aren't related with Chisholm and Grumman? So that
Yes,
could kind of
but-
argue why you wouldn't answer one. Like if you weren't confident with answering B, you might answer 2B instead of 1B.
So what y'all are saying is, although we're only required to answer 5 out of the 10, if that's what you choose, you want to answer maybe 8 out of 10 and only portions of some of those? That's what you're saying?
Sound as if they're trying to say, like, if question 1 has A and B, question 2 has an A and B, they want to answer 2B and 1A and make that one question.
Yeah, that was kind of where I think we were
Or you
going.
also, no, I mean, yeah,
Oh.
and then answer more questions than just the 5 then.
It-
Because you're just
It
gonna
wouldn't
lose
be
points for
answering
the
more
one that you
questions.
didn't answer.
It wouldn't be answering more questions, because if one has 2 parts and you answer the first part of one, and then you go and answer 2B, that's still one. Like we're asking her, would that still be counted as one question?
Right, but what I'm saying
Then
is.
10 marks each.
Suppose, okay, so that would be regarded as one question. So you will answer 4 more? So
Yes.
the points that you lose off of not answering A of 1 and A of 2, you'll make up by answering 4 more questions and getting your points there?
Yes.
I think,
That's what I thought you
I
asking.
think-
I couldn't imagine that would be what would be accepted, but
No.
okay, it seems like question 1 is that you answer, okay, let me ask it this way. Could we answer any 10 questions, whether it's part A or B? Because, okay, you said answer 5 questions, parts A and B, right? Any 5, so that totals 10 questions. So I think we need to know if we can also answer any of the 10 questions out of the any 5 questions, okay, sorry, any 10 questions out of the, any 10 answers or any 10 questions out of part 1, and it still adds up to the same thing. No?
It wasn't designed to be like that.
Oh,
Mhm.
okay then.
'Cause
no.
Right, because I'm looking to see that you have knowledge of all of the areas.
Mm-hmm. Okay.
Understood.
Yeah.
Mm-hmm. Understood.
Yes. So whatever question you answer A and
A
B.
and B, right?
Yeah.
Okay. Like
So
you
we-
can't just do A and don't do B, but move on to question 2, or do part B, but do not
Right,
do A. You
right.
have to do A and B. Okay. I think that's clear.
This question here is 2 directors. They've decided to loan a person some money, but they didn't do any sort of background check. And so now the bank can't recover the money. So in relation to the Companies Act, or I could do the Companies Act or the IBC, I want you to talk about what is this standard duty of care that's required of directors, and then apply it to the scenario and say whether or not those 2 directors have breached their duty of care.
So the bank can't recover the money?
No.
I'm gonna have to come back to this class to listen to the recording.
Okay, so in another case that we discussed, again, it was on a director's duty. Is where a parent company had settled a claim against the directors. Remember the case that we read with Mr. Hutt, who was a shareholder and also director of the subsidiary. And the parent had entered into some loan facilities, and they wanted the director/shareholder to give his decision for them to go ahead, and he had declined. You remember the case? Zone
Yeah.
America, Ferdinand Hutt. Okay, so we know that as a director, he had a fiduciary duty. So you need to discuss the court findings on the case regarding the director's duty with regard to economic loss. Because remember, the whole case was, they were suing because they say because of him not making the decision and saying no, that they lost the funds on the facility. So the question is on the director's duty with regard to economic loss. How many is that? 10?
Hold on, what's the case called again?
Zone America versus Ferdinand Hutt.
Oh, yeah, I remember that.
Mhm.
Unless that was 10A and B, that's 11 questions.
Okay, it is 11.
What about the multiple choice?
There are 20
Just-
of,
just- okay. Pardon?
I said there are 20 multiple choice.
Just random from chapter 5 to 10?
One is up, one is on piercing the corporate veil, winding up, articles of association, shares, winding up, liquidation, director and their authority, action by a non-executive, resolution, type of resolution at a meeting, shareholder rights, variation of class, transfer of shares, a bankrupt shareholder, shares again. Question on shareholders. A non-compete clause. Resolution by the board. And shares again.
You grab it for the shares, boy. I got to read that but 5 times.
I put one big asterisk next to that.
Yeah, I
The
got to
multiple
read
choice make me
shares.
want to do the whole short answer.
I know.
You never know. I think once you read it and you start to look at the multiple choice, you might know all the answers already.
You might.
I didn't even remember nothing about no action of non-executives. I gotta go look back to my manual.
Yes, that's the only thing I forget, but the rest I think I'm a little okay with. I go over shares for 3 times and I should be good to go.
Okay.
That's some optimism now. Rub that on me.
But Charlie ain't got no choice.
You have plenty time to study.
This
Lots.
is what, April 15th you said or something?
I agree.
Yes, April 15th. You have lots of time to study.
Well, I'll wait for the last minute because that's my little hidden talent. I guess we'll receive some communication. What time? Do we know what time? And how long is the exam?
3
About
hours.
15 hours, eh? Huh?
3.
Oh.
The whole 3 hours. I was sitting there the whole 3 hours.
And this is written, or we supposed to bring our laptop?
It's written.
I just check it.
It's written.
I don't even think I could write that long because I just type all day.
Well, start practicing.
Uh-huh. Pull out your penmanship book.
That's right. And make sure I can read.
Sorry. This is at BIF's office?
Yes.
Okay. And you'll
I
let us
have
know.
no clue what our office is.
Upstairs on the corner.
What corner it is? Across from the hospital?
Yes.
Across from
In
PMH.
Graham
Okay.
Thompson.
Good afternoon.
Brown.
Yeah, you park in Graham Thompson parking lot. Cross the street, go through the parking lot and go upstairs and go in the back door.
Got it right, Denise.
I had to go pick up my manual.
Ah, yes, yes.
So what time
Can
does
you
it
write with
start?
pencil?
Mr.
So,
Brown, call the
You're in
reminder.
second grade, eh?
Listen, I need to rub out when I forget something.
Scotch that out.
I haven't had to write in a very long time. That's why I said I need to write it in pencil.
I like to write.
I'm sorry, with the start time, 9 o'clock or?
No, I think it's the same time, 12:30.
Oh, same class time. Oh, okay. All right. Fine.
Well, thank you for giving us all those details.
Yes, I'm sure he
Yeah.
sent it out.
If you having a few cocktails this evening and feel real good, you could just email us a copy of the exam. We'll be willing to receive that.
Had it. No, I'll only be having 2 cups of tea.
Oh my goodness, I felt like you might say that.
Just 2 cups of tea. All
Throw in a
right.
little bit of rum in that. All right
No.
then.
You know,
But
Just a
I-
question
So
on
one more
capstone.
question.
Oh,
After
sorry.
the exam is, Arthur, what happens? We get the results, we get a certificate, what happens?
after the exam, you get the results maybe in 3 weeks, depends on the on my schedule, and then we have a award ceremony. That's
Oh,
normally
no.
September, October. No, you can come if you want. If
Oh,
not,
good.
get up.
Oh, so you can pick up the certificate and plus attend the award ceremony? Will we be mentioned?
The person with the highest grade is mentioned.
Oh.
Picture is put in the booklet. Your names are in the booklet. You'll see.
Oh, okay.
Yeah, it's a big thing because a lot of people come and their employers come out. There's people
My
in top,
employer won't even know.
whoever top student.
Oh, okay. And that's determined by the final exam or participation or what is
Oh.
it?
All.
Combination? Oh,
But is this the only company law 1 class you are teaching right now?
Yeah, and after that, I think we do another company law 1 and then we do company law 2.
Hmm.
is it recommended?
Company law 2?
Mhm.
It depends on what you do. Company law 2 is more about the products that we offer.
Who's we?
Yeah, I was about to ask that. BIFS?
Bahamas.
Oh, Bahamas. Oh,
Oh,
So we won't have cases in that class?
Not really, no.
You sure about that? Because I don't want to sign up and then when I come on, I start to hear Ms. Archer say, in the case of somebody and somebody.
no, she like press. She'll open that up with Solomon and Press.
Oh my
And
goodness.
her two boyfriends. Oh, no.
y'all ain't easy.
No, it's not on cases. It's just like if you employment law 1 is case law. Because you have to interpret the actual legislation. Employment law 2 is on different issues that happen in employment law, like discrimination and things like that. So there are some articles. If I could find some Bahamian cases, yes, but a lot of it is not case law.
Okay, quick thing on the capstone, please. Is that due the last class as well, April 15th?
Yes, but I mark.
Okay.
I normally take about 2 to 3 weeks because I have other classes to mark. So if you feel that if you're not finished
Oh, great.
of the exam the day before, you could send me an email and tell me you will have it ready like the next week or the
Oh.
week after.
Okay, so we have a little extended time on the capstone if need be.
Yes,
Okay.
just send so I know.
Thank you.
Yeah.
Thank you very much. Oh, God
Yeah.
is good.
That was
That
nice.
capstone is so meaty, I can't believe it only worth 15%.
15% is a lot.
Not compared to the 50% of this exam. I just went,
You can do it.
oh, thanks. That's what my Korean shows say. You can do it.
Yes, you can do it.
I know I can't, but anyway, this will end my tenure with classes. But anyhow, all right.
All right, so I will wait and see what you all do on the exam.
Okay.
Okay,
I-
all right.
I could buy you some nice tea right before the exam, yeah? All right, then. Take care. Bye.
Thank you.
Okay.
Take
Bye-bye.
care.
Good evening,
Bye.
everyone.
Bye-bye.
Bye.
Bye.